Good afternoon everyone, to my classmates and especially to Attorney Insomo. This afternoon I am going to discuss to you about the sections 54 to 58 of the Negotiable Instruments Law of the Philippines. Section 54 is about the notice before full amount paid, where the transferee receives notice of any infirmity of the instrument or defect in the title of the person negotiating the same before he has paid the full amount agreed to be paid. Therefore, he will be deemed a holder in due course only to the extent of the amount therefore paid by him. Effect of notice before full payment. First, no amount has yet been paid. Where an instrument has been taken but the purchaser has not yet paid anything, and he receives notice of infirmity in the instrument or defect in the title of the holder, he is relieved from the obligation to make payment. If he does so, it is quite clear that he is not entitled to the same protection as a holder in due course. Payment mentioned in the said provision is not includes money alone, but also a performance in any other manner of an obligation. Second one, the amount has been paid, where the instrument has been transferred to him in consideration of his promise to make future payment to his transferor. He is under no legal obligation to pay the balance of the amount he has agreed to pay and discovering the infirmity or defect. If he does, he can be considered a holder in due course only to the extent of the amount therefore paid to him. The Section 54 is applicable only where the obligation incurred by the holder of a bill or note is such that upon discovering the infirmity in the instrument, he is relieved from all further legal obligations to make further payments, as for example, where the note has been transferred to him in consideration of his promise to make future payments to his transferor. In that case, if it should turn out that, by reason of fraud on the part of the transferor, the maker of the note had a defense thereto, the transferee would be under no obligation to pay the balance of the amount that he had agreed to pay the transferor. However, it does not applicable where the holder has given for the paper his promise which she must perform, as for instance, when he has incurred the liability to a third person. In such case, he is in the same position and entitled to the same protection as one who has paid for the instrument in money or property at the time of the transfer. And now let's tackle the Section 55, when the title defective. The title of a person who negotiates an instrument is defective when in the meaning of this act, when he obtained the instrument or any signature thereto by fraud, juries, or force and fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith or under such circumstances as amount to a fraud. Defective title in general. First, defects of title are defined in Section 55 to cover all those situations which are known as personal equitable defenses, and also cover those equities of ownership where there is a breach of faith in negotiation. Second, infirmities then must include things that are wrong with the instrument itself as distinguished from those things that are lacking in the contracts on the instruments. Such infirmities are to be found in situations arising under sections 13, 14, 15, 16, 21, 23, 124, and 125. When title of a person defective. So that's the question that we're going to answer this afternoon. The title of a person who negotiates an instrument is defective under Section 55 in two ways. The first, in the acquisition when he obtained the instrument or any signature thereto by fraud, juries, or force and fear or other unlawful means or for an illegal consideration. Second, in the negotiation, when he negotiates the instrument in breach of faith or under such circumstances as amount of fraud, juries, or force and fear include all acts which overcome the signer's will. Good faith of taker and negotiator. The object of Section 55, when taken in connection with Section 56, is so to payment one from becoming a holder in due course who takes an instrument with notice that his transferor is not acting honestly. It is the same object as it is found in the good faith in Section 52, paragraph C, but viewed from a somewhat different angle. Said clause has regard to the attitude of the taker of the instrument, while Section 55 emphasizes rather the honesty of the negotiator as brought to the notice of the taker. The object of the whole is, however, a single one, to require a thoroughly honest and fair transaction to constitute one a holder in due course. Okay, let's proceed to section 56. It is all about the what constitutes notice of defect. To constitutes notice of an infirmity in the instrument or defect in the title of the person negotiating the same, the person to whom it is negotiated must have had actual knowledge of the infirmity or defect, or knowledge of such facts that his action in taking the instrument amounted to bad faith. The question is, what constitutes notice of infirmity or defect? So, in order to constitute notice, the transferee must have actual knowledge of the infirmity in the instrument or defect. In the title of the endorser, or knowledge of such facts that his action in taking the instrument amounts to bad faith. Actual knowledge is usually shown by the instrument itself. First, mere negligence to make inquiries not sufficient. Under section 54 and 56, negligence in itself is not sufficient to constitute notice, since it is not the equivalent of either actual knowledge or bad faith. Second, knowledge amounting to bad faith. There is difference, however, between the existence of suspicious circumstances on the one hand and actual suspicion of the holder on the other. If the holder had actual knowledge of suspicious circumstances, coupled with the means of readily informing himself of the facts, and he willfully abstained from making inquiries, his intentional ignorance may amount to bad faith. It is not necessary that the buyer of the instrument had notice or knowledge of the exact fraud of the particulars thereof committed by the assigner, since all that is required is knowledge of such facts that his action in taking the instrument amounted to bad faith. Third, effect of notice of defect. Knowledge or chargeable notice of any defect at the time of taking of an instrument which destroys the status of a holder in due course opens all defenses otherwise cut off against him, and not merely that relating to the defect of which he had notice. Thus, a holder with knowledge of a failure of consideration is subject to the defense that a note was obtained by fraud. This does not, however, modify the rule that one holding from a holder in due course may have all the rights of the latter. Notice to the agent is ordinarily deemed notice to the principal, and notice to a partner is notice to the partnership. Fourth, doctrine of constructive notice and applicable. The doctrine has never been applied to commercial paper. The truth is, as to negotiable paper is that of good or bad faith. Thus, a notice of lespendence affecting land is applicable only to a person who is dealing with the land itself, and a purchaser of a negotiable instrument secured by a mortgage on the land is not dealing in land. And constructive record notice of an infirmity in the instrument does not amount to bad faith. And now let's proceed to the facts that are not noticed. Under the United States Uniform Commercial Code, knowledge of the following facts standing alone is not notice of a defense or claim even if the holder has knowledge of the fact. First, the instrument is antedated or postdated. Second, it was issued or negotiated in return for an executor promise or accompanied by a separate agreement, unless the purchaser has noticed that a defense or claim has arisen from the terms thereof. Third, any party has signed for an accommodation party. Fourth, an incomplete instrument has been completed unless the purchaser has notice of any improper completion. Fifth, any person negotiating the instrument is or was a fiduciary. Sixth, there has been default in payment of interest on the instrument or in payment of any other instrument except one of the same series. In addition, the filing or recording of a document does not of itself constitutes notice to a person who would otherwise qualify as a holder in due course. To be effective, notice must be received of such time and in such manner as to give the holder a reasonable opportunity to act on the information. Notice must be received before the holder receives the instrument, otherwise later notice is irrelevant. In section 57, mentions about the rights of holder in due course. A holder in due course holds the instrument free from any defect of title of prior parties and free from defenses available to prior parties among themselves, and may enforce payment of the instrument for the full amount thereof against all parties liable thereon. So let's proceed to the rights of a holder in due course. So what are the rights? First, he may sue on the instrument in his own name. Second, he may receive payment, and if the payment is in due course, the instrument is discharged. Third, he holds the instrument free from any defect of title of prior parties. Fourth, he holds the instrument free from defense available to prior parties among themselves. And fifth, he may enforce payment of the instrument for the full amount thereof against all parties liable thereon. And the next is the importance and foundation of the due course holding. Section 57 shows the commercial importance of due course holding. A holder in due course acquires a right better than any of his predecessors because he takes the instrument free of most defenses available to prior parties among themselves. Thus, the fact that the instrument has been stolen or negotiated in breach of faith or has not been delivered is no defense against a holder in due course. A holder in due course may enforce the full amount of the instrument without regard to the amount he paid for it. The doctrine which protects a holder in due course is founded on the broadest principles of public policy with regard to the utility, free circulation, and credit of negotiable paper in the commercial world. Indeed, The convenience and necessities of commerce acquire negotiable instruments which can pass almost as freely in the commercial world as legal tender, and demand consequently the protection of those holding them in due course. This protection is sometimes explained as an estoppel. In other words, one putting negotiable paper on the market is estoppel from contesting the consequences and incidents of his act. It is also said that the basic principle on which paper having defects is sustained in the hands of a holder in due course is comprehended in the legal maxim that where loss has happened which must fall and one of two innocent persons, it shall be borne by him who is the occasions of the loss. The one who made the wrong possible is estoppel by his neglect. And now let's tackle the real defense available against a holder in due course. The defense referred to in section 57 that cannot be set up against a holder in due course are the so-called personal defenses or equities, as distinguished from absolute or real defenses. In fa, they are cut off by negotiation of the instrument to a holder in due course. This rule, which permits a holder in due course to take an instrument free of all personal defenses, is a necessity if commercial papers are to circulate freely and prospective purchasers are to accept them routinely and willingly. Real defenses, which attach to the instrument itself, would be available against all persons, even as against a holder in due course. In the case of immediate parties, all defenses are available. A holder, not a holder in due course, acquires the instrument subject to all defenses, whether personal or real, because he is treated as a mere assignee of a non-negotiable paper. And the last section assigned to me that will be tackled this afternoon is the section 58. It is all about when subject to original defenses in the hands of any holder other than a holder in due course. A negotiable instrument is subject to the same defenses as if it were non-negotiable, but a holder who derives his title through a holder in due course and who is not himself a party to any fraud or illegality affecting the instrument has all the rights of such former holder in respect of all parties prior to the latter. Defenses in general. Defenses are grounds or reasons pleaded or offered by the defendant in a case, showing why the plaintiff, as a matter of law or fact, should not be given the relief he seeks. There are two kinds of defenses which may be interpreted to an action upon a negotiable instrument: real, absolute, or universal defense, and personal, limited, or equitable defenses. Some defenses are either real or personal, dependent on the factual situations out of which arise the particular defense. A holder, not a holder in due course, takes negotiable instrument subject to all defenses of any party which would be available in an action on a simple contract to pay money. So, let's discuss the real defense. Real defense are those that are available against all parties, both immediate and remote, including holders in due course or holders through the latter. In other words, there are cases when a holder in due course is not legally entitled to payment from the primary party. They are called the real because they attach to the rest. That is, the instrument itself, regardless of the merits or demerits of the holder or the conduct or agreement of the parties to it. Second, this does not imply, however, that the instrument is valueless and can never be enforced. It is only enforceable against the party entitled to set up the defense, but not against those to whom such defense is not available, such as in the case of forgery, persons precluded from setting it up. Third, generally speaking, the case of the real or absolute defense is presented where the contract is void or where the contract itself is declared void by law. Usually, defense applies only to the person who has made or drawn the instrument. Personal defenses are those which grow out of the agreement or conduct of a particular person in regard to the instrument which renders it inequitable him, though holding the legal title to enforce it against the party so to be made liable, but which are not available against the holder in due course or holders with all the rights of a holder in due course. They include every defense assertable in action under ordinary contract law. They are called personal defenses because they are available only against that person or subsequent holder who stands in privity with him. In other words, they can be used only between original parties or immediate parties or against one who is not a holder in due course on the same basis as if the instrument is non-negotiable. A holder in due course takes the instrument free from personal defense. Note that while a real defense questions the legal validity of the instrument itself, personal defense affects only the validity of the agreement for which the instrument was issued. The validity of the instrument is recognized. It is the underlying agreement that is in question. So let's discuss the immediate, remote, and prior parties. First is immediate parties. Assume that M makes and delivers his promissory note to P, which is the PE, and that P endorses to A and A to B. M and P are said to be immediate parties because they are direct contractual relation to each other. Again, M and P are said to be immediate parties because they are direct contractual relation to each other. So remember that statement. Where, however, M makes and delivers to X and intermediary, his refers to M, promissory note payable to the order of P, and X delivers the note to P, who is the PE, for value. M and P are not immediate parties. Immediacy signifies privity, not mere proximity. Okay, second, the remote parties. A remote party is one who takes title to an instrument by negotiation from either the original P or any subsequent holder. In the preceding illustration, M and B are remote parties. That is, parties who are in direct contractual relation to each other. Other pairs of remote parties are M and E, then P and B. Next, prior parties. In the example given in number 1 above, M, P, and E are prior parties with respect to B. Let's proceed to the defense available against a holder, not a holder in due course. A mere assignee or one who is not a holder in due course takes the instrument subject to all valid claims of any party which would be available in an action on an ordinary contract. Some defenses are used in Section 58, does not limit the defenses since the section is not exclusive and does not prevent pleading other defenses upon entirely different character not dealt with or covered in such section but specifically permitted by any other statute. Unless he has the right of a holder in due course, any person takes the instrument subject to all valid claims or defenses of any party which would be available in an action on a simple contract. Defense subject to estoppel. Through estoppel, an admission or representation is rendered conclusive upon the person making it, and it cannot be denied or disproved as against the person relying thereof. Real and personal defenses are subject to estoppel since the rules and principles governing estoppel generally are applied to commercial instruments. In fact, practically all the defenses such as forgery or illegality may be precluded by estoppel. Let's proceed to the fraud in factum and fraud in inducement distinguished. There are two kinds of fraud relating to negotiable instrument, namely, first, fraud in the execution or fraud in factum. It exists in those cases in which a person without negligence has signed an instrument which was in fact a negotiable instrument but was deceived as to the character of the instrument and without knowledge of it, as where a note was signed by one under the belief that he was signing was a witness to a deed, or where the signature was procured by fraudulent use of carbon paper. Second, the fraud in the inducement or simple fraud. It is that which relates to the quality, quantity, value, or character of consideration of the instrument. In this case, the signer is led by deception to execute what he knows is a negotiable instrument, and therefore necessarily signed with knowledge that the instrument would probably pass into the hands of an innocent purchaser. Here, the deceit is not in the character of the instrument but in its amount or its terms. It implies that the signer knew what he was signing but that he was included by fraud to sign. And now let's proceed to the rights of holder not in due course. A holder not in due course has the following rights. First, he may sue on the instrument on his own name, as emphasized in section 51. Second, he may receive payment, and if the payment is in due course, the instrument is discharged. Third, he is entitled to the instrument but holds it subject to the same defense as if it were non-negotiable, emphasized in section 58. And fourth, he has all the rights of the holder in due course, from whom he derives his title in respect of all parties prior such holder, provided he is not himself a party to any fraud or illegality affecting the instrument. Right of holder not in due course to receive payment. It does not follow as a legal proposition that simply because one is not a holder in due course, he cannot recover on the instrument. The law does not provide that a holder not in due course may not, in any case, recover on the instrument. Example, if B, for instance, purchases from A rather, an overdue negotiable promissory noted signed by him and B, is not a holder in due course, but he may recover from him, or A has no valid excuse for refusing payment. The only disadvantage of a holder who is not a holder in due course is that the negotiable instrument is subject to defenses as if it were non-negotiable. Where checks were issued by the drawer without consideration in breach of faith, no right of recourse is available to a holder in bad faith against the drawer. So we need to remember that statement. So let's proceed to the rights of purchaser from a holder in due course. Whether a holder takes a negotiable instrument free of equities and defenses that might obtain between the original parties depends upon the further fact of his status as a holder in due course or as a taker through such holder. First, rights of a mere transferee. If a person is not a holder in due course, his rights are those of a transfer of a non-negotiable instrument so that he is not free from personal defenses. Second, rights of transferee from a holder in due course. In Section 58 provides this exception. Holder free from fraud or illegality who derives his title from a holder in due course has all the rights of the latter, even though he himself is a mere transferee or does not satisfy the requirements of a holder in due course. A. The rule has a logical basis. If a third party cannot take commercial paper from an innocent holder free from equitable defenses because such third party knows of its original infirmities, then the rights of the innocent holder are greatly reduced. His market for such paper would be limited to those who, like himself, had no notice of its original infirmities. Since the innocent holder could collect from the maker, it can make no difference to the maker into whose hands the note may pass. B. Note that there are two requisites. First, that he derives his title through a holder in due course. Second, remember that he was not himself a party to any fraud or illegality affecting the instrument. Rights of reacquirer with a defective title from a holder in due course, but a PE or endorsee who title is defective cannot better it by selling the instrument to a holder in due course and buying it again. A payee may be a holder in due course, remember, provided he meets the requirements of Section 52. It is a well-known rule of law that if the original payee of a note unenforceable for lack of consideration pre-purchases the instrument after transferring it to a holder in due course, the paper again becomes subject into the payee's hands to the same defenses to which it would have been subject as if the paper had never passed through the hands of a holder in due course. The same is true where the instrument is transferred to an agent of the payee. Next, the principle above, as stated by our Supreme Court, seems to apply whether or not the reacquirer was a party to the illegality or fraud affecting the instrument. A holder not in due course should not be permitted to wash an instrument clean by passing into the hands of a holder in due course and then repurchase it. He is remitted to his former possession. Similarly, a holder in due course who negotiates the instrument to a holder other than the one in jokers, and then reacquires it, will hold the instrument as holder in jokers. So classmates and attorney, that's all for my report about the sections 54 to 58 of the Negotiable Instrument Law of the Philippines. So thank you for listening and God bless everyone.